Do I need a lawyer to defend me in NCAT proceedings?
Only only if you're being sued for an amount that you're prepared to lose do you not need a lawyer.
And in cases under 30,000, there is no right of representation.
That's right. So the rules for legal representation in NCAT are such that parties are to be legally. There's a general rule that parties are not entitled to legal representation. There's an exception in the home building list for matters over $30,000 in value. Nevertheless, you still have to ask for leave. So in layman's terms, you have to ask the tribunal's permission to be legally represented. And really, in the home building list, in claims more than $30,000, that's a very simple process that is almost never denied. But nevertheless, your lawyer will still have to either write to the tribunal or make an application from the bar table on the first occasion to appear.
And I guess whilst the tribunal is kind of a less formal forum for resolution of disputes, and the strict rules of evidence don't apply, the tribunal members still have quite a broad power to make costs orders. So these are orders at the end of a matter where you might have to pay the other party's legal costs, or conversely, if you were successful in defending your case, or you can get a better outcome than you've offered to settle it, the tribunal can make orders in your favour. And when you've got claims that are, often there's significant amounts in NCAT.
Yeah.
Certainly not amounts that you can afford to lose. And the legal costs can, I guess, also be quite significant. So it is really important to protect yourself from that potential liability, but also the potential liability for costs, because you might be faced with a claim for 100,000 or
right.
200,000. And when you add the costs onto that, it can be crippling.
So the maximum jurisdiction in NCAT, well, certainly for the payment of money, is $500,000, and the legal costs that can go along with that can be quite substantial. I recently acted for a builder who I didn't run his claim. He came to me after the other side had obtained judgment in their favour, but he has cost orders against him in the order of a couple of $100,000 on top of $500,000 that he has to pay out.
Yeah.
So that's very substantial, and it can happen if proper care isn't taken. It can happen. So the key takeaway is any claim that's over $30,000, generally the unsuccessful party will be required to pay a significant portion of the successful party's costs.
Yeah, which is why it's so important to get proper legal advice, try to resolve disputes early, and or put forward a fair and reasonable offer of settlement that hopefully is going to result in a better outcome than the other party will get in the proceedings, so that you're in a position then to ask for your costs to be paid despite still having an order against you.
That's right.